One of the primary contingencies that has to be satisfied in the contract is the mortgage contingency. A buyer must secure a mortgage in order to complete the transaction. Typically, a buyer is pre-approved when entering into the contract. However, this is not what's called a mortgage commitment. The mortgage contingency still has to be satisfied, again, in order for the buyer to proceed. If the buyer is denied the financing, a buyer may legally void the contract and have all deposit monies refunded. The buyer will submit the loan application, provide any documentation to the lender. Once approved, the lender will issue what's called a mortgage commitment. This will signify that the buyer is approved for closing. The file is then sent to a closing department and we're able to formally schedule the closing. If a buyer is denied financing, requirement in order for the buyer to legally cancel the contract is that the buyer obtain what's called a letter of denial from the lender. This will formally indicate that the buyer was denied financing. It will also specifically state a reason or the reason for the buyer being denied the financing. A mortgage approval is not necessarily only based on the buyer. It's also based on the property being approved as well. It's not uncommon to see homeowners associations involved with the subject property having financial issues that could constitute a denial from the lender. So it's important to note that the approval is not solely based on the buyer, it's also based on the subject property and/or any restrictions associated therein, namely HOA, being approved by the lender as well. Once the lender approves the loan, again, it will issue a mortgage of commitment, which should be provided to the attorney, and who the attorney will then provide to all involved parties, indicating that the buyer has satisfied the mortgage contingency listed in the contract.